Hello, friends. Welcome to a pop-up session of Conversations in Investment Immigration. I'm Carolyn Lee, principal and founder of Carolyn Lee PLLC, an inclusive but exclusively investment immigration law firm. Well, today, the EB-5 Regional Center program sunsets, June 30th, 2021. And while we've had many sunsets between 2015 and today, it must be said that it is very different today because we do not have a reauthorization vehicle in sight. And we are also uncoupled from the other immigration programs with which we had been riding together to this point, E-Verify, religious workers, and Conrad 30 shortage area physicians. So while the Regional Center program has been renewed again and again since its foundation in 1992, it must be said that we are at a precarious moment in the program's history. And I've always said you've got to have a strong stomach to be an EB-5, and I think I do. But my tummy is doing some loop-de-loops, and I imagine that many of yours are also. So the goal today, rather than expressing opinions or speculating about the EB-5 program and reauthorization, I thought what I would do is ask and answer questions based on what we believe we know, taken from announcements from the agencies and other more decisive authority than merely just sharing my opinions with you. And the goal is to identify what we don't know so we more clearly know what is unknown. There are so many uncertainties that are out there right now that it is my sincere hope that this will help at least clarify some of the questions for you, so that you can reach out to your advisors and think more about these questions as well. So having said that, none of this is immigration advice. So if you do have those questions, please do reach out to your advisors. I'm going to try to be organized in my approach to covering these questions, again, in an effort to be as clear as possible. So we're going to talk about investors and then regional centers, those types of filings. And of course, this is relevant to the entire industry and all of the stakeholder community, because if you're a regional center, you have investors. And so how this affects your investors is obviously very germane to you. And I will touch on the bearing litigation as well at the end. All right, so ready? Let's do this. All right, question. Will the EB-5 Regional Center program exist on July 1, 2021, tomorrow? Answer, no. It expires today. Are direct EB-5 cases affected? No, because it is just the Regional Center program that is temporary or pilot that is sunsetting today. The direct program is a permanent part of the Immigration Nationality Act, so it does not sunset. Will USCIS receive new I-526s after June 30th, 2021, after today? Unknown. Answer, unknown. Whether USCIS will continue to accept 526 petitions. I will share some precedent so that we can have a sense of what USCIS has done in the past. I'm going to talk about two precedents. In December 2018, we had a sunset of December 21, 2018, and there USCIS said, and I quote mostly, "We will continue to receive regional center affiliated forms I-526 after the close of business on December 22nd, 2018. I think that's a typo. I think they meant December 21. As of December 22, 2018, the next day, we will put unadjudicated regional center affiliated forms I-526, whether filed before or after the expiration date, on hold for an undetermined period of time. Okay, so they did continue to accept after sunset, but they said that they would hold them and not work them for an undetermined period of time until there was reauthorization. March 6th, 2009, we had another sunset, and then the service said, this is written announcement, all forms I-526 received after March 6, 2009 must demonstrate that all 10 jobs created will be direct, permanent, full-time. So we see that there was a different approach in 2009. The service operated under the theory that they could continue to receive 526s, but that those 526s accepted, received after the sunset date would be decided under the permanent program rules requiring direct job creation. Whereas in 2018, the service said they would simply hold and not work them at all. Will USCIS receive new I-485s, adjustment of status applications, after June 30, 2021? Answer, unknown. Unknown. Precedent. December 21, 2018 sunset, the service said, we will continue to receive I-485 applications, just like with the 526s. As of December 22nd, 2018, we will put unadjudicated regional center affiliated I-485s, whether filed before or after the expiration date, on hold for an indeterminate length of time. So the 485s and the 526s were treated identically in 2018. In March 6, 2009, a little bit different. USCIS has not made a final determination whether it may approve regional center affiliated adjustment of status applications after the sunset, and it will hold these I-485s in abeyance pending a final determination or congressional action. So the 2009 announcement actually did not expressly answer the question whether the service would continue to accept 485s. So I think that's something we want to look out for. Presumably it did hold a position that it would, it just didn't say so, unlike in 2018 when it expressly did say so. The question arises then, if the service accepts 485s, what will it do with the ancillary benefit applications, the 765s for employment authorization, I-131s for advanced parole? So hold that thought. Will EB-5 visas be issued abroad? And similarly, will USCIS approve the 485s? No. And this is very clear in the July 2021 visa bulletin, which says no regional center visas may be issued overseas or final action taken on adjustment of status cases after June 30, 2021. That means no approval of adjustment of status applications and no issuances of immigrant visas at our consulates abroad. But note, it says no final action, meaning no approvals. Does not address whether or not the 485s may be received, and it certainly does not address what will happen with those ancillary benefit applications. Note that the State Department did confirm that immigrant visas will be issued until close of business today. So what about those ancillary benefits to 485s and I-131s that are typically filed with the 485s adjustment of status applications? Unknown. I will share that in response to litigation shared by my colleague, Matt Galati, it seems that the government position is that no employment authorization cards or advanced paroles can be issued during a lapse. Okay, but this to me seems ripe for further exploration and potentially litigation. Will Customs and Border Protection admit investors with valid 526 EB5 visas? So if you've had an interview before or till the close of business today, you're going to be issued, you investors will be issued visas or have been issued visas with a validity period of certain months typically. So as of tomorrow, we have a sunset. Will you be admitted into the United States? The answer is unknown. However, in the past, in 2009, AILA, American Immigration Lawyers Association, had a liaison session with Customs and Border Protection where the CBP official said, if the visa is valid and the applicant is otherwise admissible, there should not be an issue with CBP admitting an EB5. So if prior precedent holds, you have that valid visa investor, you may be able to come in during the validity period of the visa, you and the dependents. What if you're not yet in conditional permanent residency? 526 petition's been approved. Investor is awaiting an interview and visa issuance and to come into the United States and be admitted in conditional permanent residency. Unknown. And it must also be observed that while we have a lapse and while we know definitively that no adjustments will be approved and no immigrant visas be issued, that the backlog will lengthen in that cases can't be adjudicated and those numbers taken down so that they're off of the backlog. So a very pressing reason to hope for a reauthorization ASAP. An investor is in conditional permanent residency status already. Are they affected? Unknown, in that there has not been an announcement of which I know that expressly addresses. However, I think it's very, very likely, I will conjecture on this one, that the conditional permanent residency status is affected by virtue of the lapse in any way. Once an investor is in conditional permanent residency, I think it's fairly safe to assume that the conditional permanent residency will be valid and will continue, leading to the next point about I829 petitions. What about I829 petitions? This might be the maybe the only sort of I don't know, bright light would be too much, but it is a point of certainty or near certainty. It must be said it is unknown in that we don't have express guidance, but the precedent has been consistent. In December 21, 2018, the service said all forms I-829 filed before or after the expiration date will not be affected by the expiration of the program. Will not be affected. Let's talk a little bit about what that might mean. March 6, 2009 sunset, USCIS said the same thing. Forms I-829, whether affiliated with a regional center or not, will be unaffected by the sunset. So what could unaffected by the sunset mean? I think the first thing it means is that it's got to be timely filed. This is related to the prior point that the period in conditional permanent residency is likely unaffected. The 829 has to be timely filed, still within that 90-day window of the 2-year anniversary. What else could unaffected mean? It could mean, I believe it does, that indirect job creation reported in the 829s should still be counted as indirect, despite us having observed that at least in 2009, the service had a different position, at least with respect to 526s filed after the sunset during the lapse. So this raises an interesting question that actually came up in a conversation I had with a regional center client earlier today. let's say the 829 is reporting past job creation, completed job creation. The thing is built and or the thing is operational and we have all the jobs for all of the investors. Unaffected. So would that mean that the 829 is approvable because the job creation is satisfied? Another question, different fact pattern. What if the regional center 829 does not show completed job creation when that 829 is filed? Do we have indirect job creation? What if the project thereafter continues jobs during a lapse, continues to create jobs during a lapse? Could those jobs be given indirect job creation credit for those associated investors? Unknown. I think in the former scenario, I think that there's at least a basis to argue that based on this guidance, that those indirect job creation activities already completed ought to be credited to those 829 petitioners. Okay, solely regional center based filings, I-924s, applications for regional center designations. In December 21, 2018, the service said USCIS will not accept new forms I-924 as of December 21, 2018. Any pending forms I-924 as of December 21, 2018 will be put on hold until further notice. That makes sense. No regional center applications by regional centers. March 6, 2009 sunset, very similar. No new regional center proposals will be accepted as of March 7, 2009. There is no form number reference because the 924 form did not come online until 2010. So I think we can conclude that there are no 924 applications that the service will receive after sunset. The 924A, different. In December 21, 2018, the service said regional centers should continue to submit Form I-924A for fiscal year 2018. There's no reference, again, in the March announcements because the 924A form did not exist. And to my recollection, there was no announcement made about the more informal narrative reporting of regional center activity that the service collected before. So I think it, although unknown in that we don't have express guidance, I think assuming that the 924A will still need to be filed is prudent. 924 amendments. We know that exemplars and regional center boundary geographic amendments are also made on the Form I-924. So will the service accept those? Unknown, but presumably no. And we're going to just spend a few minutes on the bearing litigation impacts before taking questions. I think most of us tuning into developments in EB5 know that there's an order that issued June 22nd, just a few weeks ago from the Northern District of California, vacating the modernization regulations that were made final in 2019. It's a fascinating order. It's a little daunting to follow the ins and outs and the various legal theories, but it is fascinating reading, and I commend it to you to read. The bottom line is that the order vacates the modernization regulations, which, of course, among other things, raised the investment thresholds from 500 and $1 million, TEA, non-TEA, to 900,000 and 1.8 million for TEAs and non-TEAs. And it also changed the definition of high unemployment TEAs significantly, thereby restricting the areas that would now qualify for TEAs, and also eliminated state designations of high unemployment TEAs. So the order vacates the modernization regulations. And there is no stay on that. It's effective now. So what does that mean? I think it means, I'm going to go beyond what we know with 1000%. I think it means we have the old regulations as of June 22nd. Now, so that's been the assumption, I think it's safe to say, across the board. So the questions are, well, what if the government, will the government appeal? What if the government appeals? Will the government try to reinstate the regulations? If so, what would that process be? How long would that process take? All of those are truly unknowns. Now, notably, the plaintiff there in Bering sought to enjoin the government from reinstating the regulations absent APA rulemaking. Okay, so recall that with the modernization regulations, there was notice of proposed rulemaking in January 2017. And so they were not made final until 2+ years later. So if that entire rulemaking process were engaged again, it would take a while. And the plaintiff sought to enjoin the government from reinstating the rules without following that lengthy APA process. And the judge declined to grant that remedy. So one of the questions is, could the government reinstate the regulations without that lengthy APA rulemaking process? So something we need to be looking for. Appeal. What if there's an appeal? What if the government appeals to the Ninth Circuit, which is the Court of Appeals having jurisdiction over Northern District? What would be the effect of that? Would there be an automatic stay of that order? I think that is a question. And my understanding is that there is typically a stay if there's an appeal filed, but some think that in this instance, a stay will not be granted, which means the old regulations would continue to be in effect even if an appeal were filed. Direct cases. Again, direct cases can be filed. This is under our prior discussion of the reauthorization or the lapse impacts. Can they be filed at the 500K level? I think the answer is yes. Regional center cases, can they be filed under the 500,000 investment threshold? That is truly the question. And it turns on, I think it really turns on whether the service will accept 526s after today. If it accepts cases after today, then we have a question as to what regulations apply to those cases. If the service doesn't accept, then the question doesn't get asked. So it was my intention to just share what we know, or at least what I believe we know. And hopefully that's been a helpful exercise. I am going to take a few questions before closing off. I did not intend this to be a very lengthy presentation. So let me take some questions. One is, and again, remember, we can entertain some questions, but this is not legal advice. So please do consult an attorney who's engaged for these questions. Okay. My client just got her visa yesterday. Congratulations. Can she travel to the US after June 30th? Does CBP let her in, and will they stamp her temporary 551 on her passport as before? I think this is one of the questions I classified as unknown. And it's pretty important before they undertake that big trip in many instances before coming here. CBP has not addressed that question specifically yet. Hi, Carolyn. Hello. Do you agree that during the lapse, no IVs may be issued or adjustment of status applications approved? Yes, yes, I think that is clear based on the July 2021 visa bulletin. We have quite a few questions coming through in the chat. What impact would the sunset have on those who have been approved for I-526s and who have filed for adjustment of status, EAD and travel? Right, so we touched on this. It is unknown, but I think that the threshold question is whether the service will continue to accept 485s. The service has a number of pending 485s. And so to me, the more immediate question is the service going to issue EADs and advanced paroles for those pending 485s? And as I said, I think that is an issue that bears research, exploration, and if it doesn't come out in the way of the applicants, I would think that there would be basis for litigation. How does the sunset date affect individuals with approved 526s waiting consular interview? So this is a question that relates to National Visa Center, NVC processing. Regional Center Base 526 approved. Now we're going into a lapse. What is the Visa Center going to continue to process those cases, issue fee bills, and issue questions, begin to get those cases toward being documentarily qualified? I don't know. And I do not know of an instance where this question has been answered in the past. And unfortunately, because the National Visa Center has been so delayed in moving forward with those approved 526 cases, that we don't know, and we don't have good prior data with which to compare what we're going to see going forward. So I think that this is a question that is ripe for advocates and attorneys to be asking the National Visa Center, what is going to, how are the visa applications, the DS-260s, going to be handled during a lapse? And I will observe that it's a slightly different process for these cases to get in queue, because with a 485, with an adjustment of status pending 526 approval, pending after 526 approvals, the applicant has to make an affirmative application with USCIS. The cases have to be receipted. So there's a gating question. With DS-260s, we don't, because the A files get automatically transferred to the State Department and the fee bills automatically issue. So it's a different process. We'll have to see what the State Department's position is on this. Do you see any risk for those? And by the way, these are chats, and I believe everyone can see these questions. So feel free to respond back if you see a question that you'd like to respond to. Do you see any risk for those who have applied to remove conditions on permanent residency status? Right. This is the interesting scenario that I raised before. I would assume that you've got to timely file your 829 no matter what. And if your project has completed job creation, I think there is a strong basis. I would certainly go to the mat in arguing that that 829 is approvable, assuming that the sustainment requirement is also met. There is more of a question where the 829 does not present completed job creation. For investors watching, please help join the advocacy efforts. Yes, so one of the things that I have been kind of energized by during this reauthorization push is that investors have mobilized. They've gotten active, they're engaged, they're learning, and they're getting involved in the advocacy process. And that organization that's posted in the chat, AIIA, is one of those organizations. And I see that there's a website there. So I encourage folks to check it out and get involved. It makes a difference on all levels. Since the EB-5 program is expiring, could Congress reauthorize the program with the modernization regulations as a part of the reauthorization? Yes, it could, in that Congress can do anything, or it can propose to do anything, and it could pass. The question is, would it? Would it? And many of you listening may know that we've had, it's been difficult to get legislation in EB-5, really, in immigration generally, right? And EB-5 maybe particularly since 2015. So, and those issues, not the integrity measures so much, the so-called integrity measures that would increase the oversight administration requirements of regional centers, but more the investment amounts, really the differentials between the TEA and the non-TEA investments, and the definition of TEAs. Those have been more, they've been more controversial. And so the question is, if those issues that were taken off the table legislatively by regulations, if they were reintroduced into the legislative process, what would that look like? I mean, we were very, very, very close with the 5-year or the multi-year reauthorization proposed by Senators Grassley and Leahy in SE 31. We were very close to unanimous consent, 1 vote short of that. So yeah, we will just have to see how the legislation reauthorization drama continues to unfold. A few questions to cover if we have time. I hope you can post a recording of this very helpful webinar. Yes, we will, or we will try. Regional Center applicants, as of this week, we're getting visa interviews scheduled for July. Thoughts about what that meant? I think the close to consensus, if not consensus, is that unless there is reauthorization, there will be no visa interviews. And I think the visa bulletin, July 2021, pretty much settles that. Visas will be issued as of close of business today, but thereafter will not be unless the program is reauthorized, unfortunately. The July 2021 visa bulletin chart B is still current for regional center categories. So can regional center applicants assume that they can move forward with all consular stages of their visa apps up to final action? That's an excellent observation. And by the same token, that would suggest that adjustment of status applications could also continue to be accepted. Now, I think that whether or not the 485s are going to be received, I think that's squarely in USCIS's domain. So the State Department could say, really more for their processing purposes, that they encourage applicants to get started collecting their biographic information, getting ready to start their NVC process. It is separate from the adjustment of status process and USCIS's policies for how they handle adjustment of status applications. So, but that's not unhelpful. If principal people can move forward with visa applications, does USCIS really have an excuse to not process regional center I-526s? It's just a regional center material change issue. Yeah, well, I mean, now we're talking more opinions. I mean, I've always taken the view that there are unknowns and we should be candid about that with respect to what happens during a lapse, because we don't have hard authority. We don't have statutory guidance or regulations or even policy in memorialized form, like a policy manual regarding what happens during a lapse. So that can cut both ways. There is room, I believe, to argue that those cases should be processed or can be processed. So this might be the time to further explore those arguments. Or shall we say, this is the time. What about expedited requests being approved in mid-May? Are they obligated to process? Are they obligated? Oh, I see. I think the question might mean, what if the expedite was granted, but the underlying benefit petition is still pending? Does the expedite mean that the service is required to adjudicate the underlying petitions even though we have a lapse? I don't think so. I don't believe that a grant of an expedite is an automatic conferral of some obligation, just by itself for the service to adjudicate the petition. I'm going to switch to the webinar Q&A because we have a bunch accumulating there. To recap, hi, those with pending 485s will remain on hold and ancillary benefits, EADs, will not be adjudicated. Unknown. USCIS has not said what it will do with pending 485s, and certainly not ancillary benefits. And other practitioners may have a different read. I think to me, at least with EB5 adjudication, it feels a little early to be able to get a feel for attitude. What is the attitude toward certain cases or certain issues presented in cases, not yet crystallized. So we don't have answers to those questions yet. I wish we did. We might start to get those really quickly in litigation. Hello, our expedited request was approved in mid-May. Are they obligated? So yeah, we answered that. My lawyer answered an RFE in February, still no answer. What happens in these cases? I think that if it's 829s, you're in a better position. If it's a 526 or 485, not certain. An investor has been scheduled for an interview in mid-July. Yep, so we answered that question. Probably not. No interview will be granted during a lapse. Will pending I829s be put on hold? Or I should say, allow me to backtrack a little bit. No visas will be granted during a lapse, for sure. That's based on the July bulletin. Interviews are not issuances of visas. So I will say that we do not have anything definitive on visa interviews. And I would love to see interviews continue to go on so that all of those cases can kind of pop up and the visas be issued once there is reauthorization, right? Will pending I829s be put on hold? You answered that. Excellent presentation. Thank you. Why, thank you. When do you think the sun will rise again? Or when will we have a clearer picture? I don't know. I don't know. And I wish we had a clearer picture. And in my view, we don't yet, because there is no vehicle ahead. So in the prior sunsets, there was a vehicle ahead. There was the appropriations bill, whether it's a continuing resolution or budget for the remainder of the year. We don't have that because we're uncoupled from the appropriations process. So that's the situation. For people who are in the US and awaiting 485 adjudication, but do not currently have another valid visa status, will their state continue to be legal only the EB5 Regional Center program is affected by the sunset. So all of your other benefits, consult with your attorney. What are the necessary steps, timeline for reauthor? Same answer. I don't know. What about the infrastructure package? That is a possibility. We'll be keeping our eye on that. I'm going to turn more back to the Q&As and chats for a few more minutes, and then we're going to call it a day. Okay. People are only sending questions to the panelists, so we cannot see them. Sorry. I've read aloud, I think almost all the questions, so I think we're covered. We cannot see the chat. That's okay. I've read the questions, so I think you've got them. Here's a response. Great. I checked with CBP and U.S. Consulate before I left to the United States with an I-5 visa. The answers were positive. Thank you. Thank you. Thank you for that valuable feedback. This was the U.S. Consulate in Guangzhou. Now, this was before sunset, but or was a question specifically posed about the sunset. It is positive that the question at least was asked and the answer was favorable. So just want to make sure I'm capturing these questions. There are rumors that they could move with some immigration reforms with the infrastructure bill, but could reauthorization of regional centers be part of this? When could this happen? No earlier than mid-July, when Senate resumes its session, but definitely something for us to be watching very closely. For investors watching, please join the advocacy effort to protect their interests. Yeah. After the sunset. Okay. So the kind participant who told us about Guangzhou's statements about, well, it was Guangzhou checked with CBP and the consulate. So we have some evidence to indicate that the CBP will take a similar position from the last and admit that's my feeling as well. We'll just have to see. All right. Oh, goodness me. More questions. Maybe I'll take one or two more. This is interesting. FYI, we had filed a petition for TRO, temporary restraining order, that we lost, and government attorney agreed to adjudicate the 765, but not the 485. Very, very interesting. So that would suggest that, I mean, I don't think the government would agree to something that it was not authorized to do. So I think that is a very, very favorable news. Thank you so much for sharing. And if you would please share whatever you can about that, I'll make sure that it gets disseminated out to the participants. Great. Well, I want to thank everybody for joining me at this time. And I sincerely hope this information was helpful. Tune in. We will try to send out as much timely and helpful information as we can during this time particularly. So thank you.